Does the 14th Amendment to the U.S. Constitution require states to issue marriage licenses to same-sex couples and to recognize legal same-sex marriages from other states? To find out, you have to read Obergefell versus Hodges, but it's 46 pages. Don't have time for that? I've got you covered. This is TLDR, too long didn't read. Normally I cover New York Court of Appeals cases in 5 minutes or less, but this episode is part of a special series, a limited series I'm covering on LGBTQ plus cases of interest, and this is an important one. This is Obergefell versus Hodges, published by the United States Supreme Court on June 26 of 2015, and the citation here is 576 U.S. 644. I'll attach in the description a link to that decision. The issue in this case is the right to marry a fundamental right that would be guaranteed to same-sex couples, such that every state should allow same-sex marriages and that every state has to recognize the marriages performed of same-sex couples in other states. The law you have to understand to appreciate what's going on here is that there's a 14th Amendment to the United States Constitution that importantly, and for the purpose of this particular kind of case, says that no state shall deprive any person of life, liberty, or property without due process of law. And cases that interpreted that section have said that there's a substantive due process right. There's a substantive area of law that's protected by that clause that protects fundamental liberties, which have included things like individual dignity, autonomy, the ability to have a family, to have children, to educate your children. These are things that are fundamental rights. What are the facts of this case? There's actually 3 different cases that are combined for appeal. Obergefell versus Hodges is one of them, and there's 2 others. There's a Michigan case here where there's 2 women named DeBoers and Rouse who have a commitment ceremony and have 3 children in common. The problem is that Michigan only permits opposite-sex couples or single individuals to adopt a child. So each of the women in this couple that have 3 children in common can only be the parent of one. Can only be the parent of one of these children. They can't have both women as their parents. So if this emergency arose, the other woman would not have the legal rights over the children that they share in common. The second case is Deco and Castora. These are 2 men who live in Tennessee that got married legally in New York. One of them is a National Guardsman. Every time they go back to Tennessee, the state considers them not married. They don't recognize New York State's marriage. And the last one is Obergefell versus Hodges. Obergefell and his partner, Arthur, live in Ohio. Ohio doesn't have same-sex marriage, so they went to Maryland where they got married. 2 months later, Arthur died, and they would not list Obergefell as a surviving spouse, even though Maryland recognizes Obergefell as a surviving spouse. So he's suing to be recognized as a surviving spouse. What's the majority? What's the decision here? This is a 5-4 case. This is a 5-4 decision. The majority is written by Kennedy, and the decision here is that the right to marry is fundamental, and it cannot be deprived to same-sex couples, and states cannot choose to ignore marriages that are performed in other states. So what the issue here, according to the majority, is to determine whether the right to marry applies to same-sex couples the same way it does for opposite-sex couples. You have to look at the 4 principles that underlie marriage, the right to marriage for opposite-sex couples, and see if they apply equally for same-sex couples. And Judge Kennedy goes through those and identifies them as follows: that the right to personal choice is inherent in the concept of individual autonomy, and the decision about whether or who to marry is one of the most important and momentous acts of self-definition. So marrying someone is itself an act of autonomy, which is fundamental, and that applies with equal force to same-sex couples as it does to opposite-sex couples. The second thing is that marriage is a unique union. Unlike any other, it's a commitment by one partner to another partner to take care of them when they can't take care of themselves. That's the same for same-sex couples as for opposite-sex couples. Number 3, it safeguards families and children and draws meaning from related rights of child rearing, procreation, education, the same for same-sex couples as opposite-sex couples, and that marriage is a keystone of social order, and there are a lot of other fringe benefits or responsibilities and rights inherent to marriage, the same for same-sex couples as opposite-sex couples. And because all these 4 principles of marriage apply with equal force to same-sex couples as opposite-sex couples, Judge Kennedy says you can't deprive same-sex couples of this right. It's fundamental. They address the counter arguments against it, basically the arguments being that this should be left to the democratic process, that it's too soon, we're cutting off the conversation, that it harms that allowing same-sex couples to be married harms the term marriage for opposite-sex couples, and that First Amendment allows opponents to oppose same-sex marriage. And basically, Judge Kennedy and the majority says these are not reasons to deprive same-sex couples of the ability to get married. So the two major holdings, according to Judge Kennedy and the majority, is that number one, same-sex couples may exercise the fundamental right to marry in all states. No longer can a state say we don't recognize we don't offer marriage to same-sex couples. They have to offer it to same-sex couples just like they would to opposite-sex couples. And secondly, that there's no basis, that the only rationale that a state could give to not recognize another state's marriage would be animus, would be mean-spiritedness, and that's not a legitimate basis. So basically, every state has to recognize every other state's marriages, even of same-sex couples, and every single state has to offer same-sex marriage. There's a lot of dissents in this case, a lot. There's a dissent by Roberts, which Scalia and Thomas joins. There's a dissent by Scalia, which Thomas joins. There's a dissent by Thomas, which Scalia joins. And there's a dissent by Alito, which Scalia and Thomas join. They all basically say the majority has it wrong here. The majority overreached. They impeded on the democratic process, and that this is going down the wrong road. But I would note here that the majority decision here is that same-sex marriage is a fundamental right that cannot be deprived to same-sex couples, and that basically that no state can discriminate on the basis of marriage against any other same-sex couple or same-sex legal marriage that's been performed. But I would also note that this is a 5-4 decision in 2015, and the court has changed a lot since 2015. And I don't know that this decision is going to stay that way. I have a feeling this may come back to the Supreme Court sooner rather than later, and I'm curious how they're going to decide. That's Too Long Didn't Read, Obergefell versus Hodges. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.